We're opening the Oldham County Code Enforcement Board meeting of June the 7th. We're going to start with new business. The first citation.
Good afternoon, everybody. The first case is case number,
Let me just swear you
I have
guys
to be
in.
sworn in, that's right.
Do you solemnly swear or affirm that the testimony you're about to give this board is true and correct to the best of your belief and knowledge?
I do.
I do.
Okay. The first case is case number 170034. The address is 4507 Timothy Way in Crestwood, 40014. The owner of the property is Billy J. and Lucille Liddell. They're the owner of record, reside at that address. Hearing was not requested. The violations were the burn ordinance, KOC 05-320315, sections 2. Open burning in section 3. Open burning is prohibited from May 1st through September 30th. To update everybody on the case, I've got South Oldham Fire Department's Chief Eddie Turner present, that he responded to the incident. So let me bring him up and he can tell you all exactly what happened. Chief Turner?
You'll have to be sworn in.
Do you solemnly swear that the testimony you're about to give this board is true and accurate to the best of your knowledge?
I do. Good afternoon. On April 9th, we was dispatched to Timothy Way on a possible structure fire with a guy there trying to burn his house down. Once we got rolling, dispatch come back and said actually he was burning some stuff about 20 feet from his house. At that time, I went available, but my fire engine and assistant chief continued on the scene. Also, the police were responding because apparently there's been some issues with this guy in the past. I went back home, and then about 5 minutes later after I got home, assistant chief called me when we come back up there to the police want to write this guy a citation for open burning. So I responded back up to her. At that time, they was talking to him, and they said that he was burning a pile of clothes and trash behind the house. We wrote him a citation for that, and then I turned it in to Darrell. I did go back in my files. In the last 3 years, we've been up there 3 separate times for open burning, and also one time where their garage behind the house caught fire and burned down also. So it is a trouble spot. Police wanted me to write citation so they can have a kind of like a paper trail at the residence. So other than that, I'll ask them if they have any questions or anything.
So the citation was written by Kevin Parker, the
He's an
assistant chief,
assistant chief, yes.
and was handed to the homeowner at that time.
Yes. Mhm.
Okay.
Let me just fill in a gap here. You don't see very many cases like this, and you might see a couple more. We do have an open burning ordinance, and it's been in effect for a number of years. Typically, if it's leaves or branches, the fire department might just put it out, tell them that there's a no burn, and kind of just drive away. But in this particular case, he wasn't burning leaves or branches, it was household material, which is that's irrelevant in the burning ordinance. That, you're not supposed to burn that stuff outside at any time.
Period.
because the fire departments have citation ability but not fine and fee collection ability, they turn it over to the Code Enforcement Board. Eventually, we're going to see the same thing with false alarms. Fire departments are dispatched because of or police departments because of burglar alarms or alarms in the homes, and they have an opportunity to correct them. And obviously, if it's a thunderstorm, whatever, we don't give them a citation. But after a while, it's expending county services to go to these when there's a regular and habitual false alarm. And same situation there. The police department doesn't have the ability to. They can write the citation, but we're kind of the fining portion of it. So that's what you're being asked to consider tonight, given the evidence of Chief Turner, and you can certainly ask him any questions related to the incident itself.
Yeah, like Mr. Urban said, that Judge Kinzer, I think, put this in effect 10 years ago whenever, and this is only second time they ever wrote one, so it's being few are between.
I don't have any other questions for Chief Turner.
Anyone else have any questions?
No.
Okay. Carol, I have a question of you.
Yes.
The citation date is April 9th,
Yes.
and the citation that you wrote is made.
Yes, ma'am. This is a copy of the run report generated afterwards. If you look at the date, the actual date is May 9th. That was the date of the incident. Apparently, it was a typo and it was handwritten
Okay,
on the citation
need
itself.
that clarification. Thank you.
So the actual incident occurred on April the 9th,
No, it actually occurred on May 9th.
May the 9th, and so Mr. Parker just wrote the wrong month on here. is all it
Exactly.
Okay.
Okay.
I have a question for, I guess, Mr. Urban. Does this, the burn ordinance falls under the same fine schedule as nuisance and zoning ordinances?
There's no other direction in the ordinance regarding amount of fine, so the answer is yes. It's obviously a one-time incident.
Yes.
And you do have, somebody appears to represent the property owner.
Okay, so,
Okay.
all right, then we'll go ahead and proceed with the procedures. You are here to speak on behalf?
Of the property owner.
All right, I'm going to ask you to come up, please, and raise your right hand.
Get all this stuff out of my head.
Do you solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your knowledge?
Yes.
Please state your name and address.
It's Donna Whitman, 7314 Floydsburg Road.
Okay, proceed.
Okay, well, I'm the daughter of the homeowner there and the one that actually called this incident in. And so, because Timothy Morrow, he had called my mother, which is right now staying at my house. She's not staying at her house because due to some repairs. But Timothy was over there. And he was mad at her. And basically he called and he said he was gonna burn all of his stuff and he threatened to burn the house too. Well, that's why I went over there to see what he was doing. And when I arrived, he had a small fire in the backyard. I called 911 and told him that he did have a small fire there in the backyard and that I did not want to go and approach him because he was mad and I was afraid that would escalate the situation and make it worse. So I stayed like 2 doors down in my car on the street until Officer Wolf got there. And then he told me to stay in my Jeep and he would handle it from there. And he talked to the fire department and everything then from there.
Okay, I appreciate it. Anything else you need to add at this moment?
The only other thing is that we were not aware of any kind of citation, anything from the fire department until this come in the mail with this court hearing. And so because there was no citation that was left with anybody on the scene.
All right, thank you. Please have a seat. Is there anyone else here to speak on behalf of this?
I'm with her, but I couldn't get up here because I had to sit down for a few minutes, catch my breath. I'm here now. It doesn't matter, I can't really talk to you, but you know, whatever.
Pretty
I'll
much I
check.
was the one on the scene.
Because I wasn't even there, I didn't know about any of this until I got this in the mail. That's the first I knew of any of it.
I don't have anybody else.
All right, and there's no one here in opposition. Okay?
You know, well, I'd like to clarify, I guess, if we could ask Mr. Turner, Chief Turner to come back up, just to clarify about the ordinance, the citation. The citation that your assistant chief wrote was handed to Mr. Morrow the day of the incident.
Correct.
But the lady that just testified was not aware of an ordinance. I guess she was not at the scene, so.
No. No, but yes, he was handed the citation.
Okay. Thank you.
He went to jail and evidently his citation got lost somewhere. It was in his belongings when he came back from
sorry.
jail. Oh, I'm so sorry. I'm so sorry. I'm so sorry. I've never done this before. I'm so sorry.
If she wants to speak, she needs to come
I'm
up
so
front.
sorry.
Okay.
Would you?
No, it's okay.
Okay.
Okay? Any questions of the board? Of any-
Well, I do. Who's responsible for the citation? Is it the property owner or the person he handed the citation to?
That's a good question. I wish we had legal counsel here because, of course, anytime we have code enforcement, it's related to the owner of the property. And it's obvious that the owner of the property wasn't the one who lit the fire and from testimony. And so, I guess my answer without giving legal advice is I think we really need to direct it to the person who was responsible for the fire, not the property owner. Otherwise, what will happen is we'd be making them pay the fine, and if they say, wait a minute, it wasn't my fault, then we place a lien on their property. I don't think we really want to do that. I think we really want to.
Their house was burglarized and
You're right. Yeah, so I think we really want to direct any decision towards the person who's on the citation.
can we do that?
It's an unusual case. I don't see why not. And I've texted Tate to see if he's coming to substitute, and I haven't gotten an answer back yet, so maybe what I'll do is,
Should we just table this for a few minutes?
yeah, let me go to.
Here's Tate. Here's Tate.
One minute.
There he is. We got a legal question for you to jump right into.
It's all right, I have allergies too. We won't sneeze on each other.
Hey, let me
All right, Jim's
let me
gonna update
summarize this case for you. It's a violation of the burning ordinance. And when we do code enforcement, we always cite the property owner because they're ultimately responsible. But the property owner is not who lit the illegal fire. The citation was handed to the person who was there with the fire. So I think the question of the code board is, it's an unusual case for us, is how do we make sure that we take action against the responsible party, not the homeowner? The homeowner's present, and offer testimony that there's an issue with the person that lit the fire. Well, Tate, put your
Put your mic on.
mic on, yeah.
It's all right. And you're going to have to come forward. You're going to have to,
Right, it's a
Who
good-
is this individual? Is he a tenant of the property owner?
Just a moment.
Let's swear her in.
We're going to swear you in, okay? And you're going to give us your name and
Okay. My name is Lucilla Dale. I live at 4507 Timothy Way, Crestwood.
You're the
Okay, just a moment.
Yes.
Okay, go ahead and be sworn in.
Excuse me, ma'am. Do you solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your knowledge?
Yes, ma'am.
The individual that we're speaking of, is he a tenant of yours?
No, he's my grandson.
What's he doing on the property?
Okay, he's got a really bad alcohol problem. He's been in and out of treatment centers. He's been in and out of jail. And he was waiting to go into a treatment center. And Judge Wheeler had ordered him to go into a treatment center to get clean. And we were waiting to get one open. Well, in the meantime, they had put a warrant, he had a warrant on him in Oldham County.
You got heard enough on that. The question I have for you, was he living on the property at your,
No, he was spending the night there because he had no other place to go.
with your permission?
Yes. He had my permission to be there because he had no other place to go.
Understand, well, the ordinance is for the property owner. That individual was there with the permission of the owner of the property, and it's a little unusual, but it still is the owner. It had been some trespasser or some other person of that nature, then I don't think the property owner would be subject to it. But in this case, I do think the property owner continues to be subject to the ordinance.
Okay.
But that individual was there, with your approval, and it's your responsibility to see that a tenant or anyone else follows the proper rules and regulations of the county at the time. So my position would be that the property owner would be the one that would be subject to be cited. Now, when the citing officer arrived, you gave the citation to the individual. I don't know what transpired, but I still of the opinion that the property owner is the proper one to be cited. Now, how that gets in the owner's hands is another issue.
No, you'd have to come up here.
Come in.
Has she been sworn in?
On that, like I said, would it make a difference that he had said he was gonna do this and we told him no, and I went to the property to see what he was doing, and when I seen the small fire in the backyard, I called myself here. Would that make it any difference in it? Because he did not have permission to be doing a fire, and when he done it anyway, I called.
Well, I understand that, and that's the right thing to do. It's whatever the board feels is the most appropriate way to handle it. I'm just responding to the question, would the property owner still be the one that would be responsible under the ordinance? And yes, my position is yes, but there are other extenuating circumstances, so to say, as to how this is to be handled by the board.
My question now is, since we've been directed to cite the property owner and not the individual that was in violation, that the property owner has now not been properly served, since they were not aware of this until they've never seen the citation according to
right.
I just
testimony.
got this letter in mail.
That
It's the
was
first time I'd seen
that
it.
was my, when I stated, well, this happens all the time. The sheriff's department goes out and serves a warrant or something, or serves papers on most of the time they'll ask, well, who is this individual, and get proper identification, and what are they doing there if it's not the right person. In this case, maybe what should have been done was, who are you, why are you here, and who owns the property, that kind of
Yes,
thing.
yes.
So that's kind of where we are with that. Evidently, the property owner was not aware of all this, so. But yes, in a way you were, because you were aware that the fire took place, but you called
But
the,
that's what I said, he threatened, so that I went to the property, and when I seen he did have the fire, I called 911. And then Officer Wolf showed up, and when he showed up, he told me to stay with my car and that he would go down there and handle it. So from then on, he talked to the fire department, everybody else.
yeah, well, I understand that, and the citation then is followed up by code enforcement officer and whatever, and so, again,
Well, in this
This-
case, it wasn't. The citation was properly written by the assistant chief for the South Oldham Fire Department, because they have that authority when they see a burn ordinance violation. But it was handed to the grandson, Mr. Morrow, not to the property owner.
he obviously didn't, was this lady there when all that took place?
I was down the street because Officer Wolf had told me to stay with my car, and he talked to the fire department and everything. I never spoke with him.
What is her position? I mean,
She's my daughter. She's my daughter. I can't drive after dark, and she went to my house to see what he was doing, because I can't drive after dark.
Excuse me.
well, again,
She
the
ain't
ordinance is
right good
written
at
so
all.
that, in this case, it's the property owner's responsibility, but like I say, there may be extenuating circumstances of where she was never notified, in appropriate channels, and then the board will have to make a decision as whether or not you think it's appropriate to continue with the violation.
To me, it seems this is more of a police matter than a code board.
Well,
Well, not-
but it's a violation of the burn ordinance,
Right,
so,
that's-
so that particular issue is not a police matter.
That's correct.
All the other stuff might be, but can I ask a question, Madam Chairman?
Please.
Where is your grandson now?
He's in a treatment center in Ashland, Kentucky,
Okay.
for
So-
drugs and alcohol.
So the issue is, if we were to cite the individual, how do you find them to say, okay, here's your fine? It's kind of a sticky wicket, so to speak. that, You know, the owner of the
You-
property may not be
Excuse me.
responsible, somebody else was, but, and I get you're right in the advice of who's responsible.
And I'm sorry, I haven't read that ordinance, but it specifically directs to the property owner.
It does,
and
it
not-
does. Yep. Yep.
Well, two things that I have concern, well, the first is the fact that the property owner was not properly served. So that's tough for me to find anything on their part. And the fact that the lady did call 911 to report it, they were not intentionally encouraging the fire. And then, it is difficult to find Mr. Morrow, because we don't have an address for him, or he doesn't live at that property.
Well, my guess would be if he's in Ashland in a rehabilitation, he doesn't have the means to pay a fine anyway, and we're probably not gonna get it. My thought would be, if we go through the procedure and hold anything in abeyance, and just put an end to it so these good folks don't have to come back again,
Why not dismiss it?
I thought.
Because it comes down, there was a fire that
Yeah.
happened during the burn.
Recognize that there was an issue, but then, Larry, what about the proper citation of the property owner? They weren't properly cited.
Well, I mean, they've got the citation in their hand now, and I don't see any merit in dragging it any further.
I don't either.
I mean, we can come to a conclusion and end it today.
Yes.
I agree.
Nothing
Go
wrong
right
with
ahead.
that.
Are we ready to go forward?
Thank you.
You want me to sit down, it's fine.
Make a motion to dismiss, I guess, if that's what your procedure is
Well-
on that. If that's, I mean,
Well,
somebody
but
needs,
but
somebody needs to make a motion, whatever it is.
It's, I guess what I'm saying is, there is a violation at that property. So I think we need to recognize that
Yes.
there was a violation,
But
if that's
hold
what the board so
everything in
chooses to
advance.
vote that way. And then we can choose whether to fine or to release the fine.
So in my thinking, in procedural matters, we would note that the homeowner was not properly cited, but we did recognize that there was a violation.
And Chief Turner, let me ask one more question. I don't think you need to come up. When you said 3 other occasions, was it the same individual?
I can't answer that. I just pulled a report.
Okay, all right, okay.
That's not,
That poses an interesting, you see, 3 times this has happened on the property?
he does need to come forward. Chief, you need to come forward, please.
Like I said, I pulled, from past records and then, they're highlighted.
Since you put it on for the rest
I
of
don't
the,
know how to do it.
Darryl will help you.
But it was, see the one that the question there is about the third column over 5/9/2017.
Yeah.
That's one in question, and then you see the one, 2011 unauthorized burning, and 2015 unauthorized burning, and then, last year, 2016, February, like I said, you weren't here, but their garage, caught fire and burned also. So, that's just, I just pull it up in, for history of the past runs there.
so,
But our citation
So,
is for a particular day.
Chief,
you got, you,
Chief Turner, if we go back in history, 2011, an unauthorized burning, 2015 unauthorized burning, 2016 building fire, that was the garage.
Right.
And then 2017 unauthorized burning.
That's, the 2017 is the one that.
That's the one we're talking about
Yes,
here.
yes, sir.
and that really is the only one that you
We
can
can
deal
talk
with.
The rest of them aren't before us.
No, but,
And, but we're only being asked to look at the citation on May the
Correct.
9th.
correct.
Because that's what the citation was written for, was May the 9th.
Okay.
Sure.
Back up.
And for attorney, like Mr. Urban said earlier, this is new to us, and this is only second time I've done it in 10 years. And I can understand procedures if we didn't, give it to homeowner,
Right.
that's no problem, that's no, it's no really big no deal to me, so, I know y'all got a job to do, so where you decide, it's okay with me, so, it's no big deal.
Thank you, Chief. How would we like to proceed? We have, we have before us the citation, and they're here. So,
Larry, why don't you start with your motion, and then we'll go from there.
okay.
I make a motion on the procedural matters as a citation was issued to the occupier and the cause of the fire at the time of the incident. The property owners are here. As outlined by the ordinance. And that concludes that motion.
Okay. We have a motion that in procedural matters, that the citation was issued properly. Do I have a second?
Second.
Okay, we have a second. All in favor, say aye.
Aye.
Opposed, nay.
Nay.
Okay.
Let me find the violations.
That'd be other violations, Larry, number
Be under-
4.
Under page 3 and 4, I suppose.
And from the citation, it's 05-320-315 is the ordinance.
I so moved that nuisance ordinance violation is in violation of the burn ordinance KOC 05-320-315, sections 2 and 3. Is properly issued. The violation was observed by Chief Turner. And I believe that concludes my
Okay.
motion.
We have a motion on the floor that the violation took place on May the 9th for KOC 03520-15, sections 2 and 3. Do I have a second?
Second?
All in favor, say aye.
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 Opposed, nay. Motion carries.
Do I move to determination of penalty?
Yes.
I make a motion in light of the testimony given today and Chief Turner that we dismiss the penalty phase. Check that.
Well, yeah, what you want to do, I believe, is under item G, that all or part of this civil fine is, if there is a fine, is waived and held in abeyance subject to the.
Yes. Yep, hold it in abeyance.
I make a motion that, so strike my first motion, I make a motion that in determination of penalty, help me with the language again.
Any penalty that would be assessed is waived and held in abeyance, subject to the respondent complying with any
Okay.
and all the following terms and conditions. That is, not to permit any further violations of the ordinance.
The board recognizes that a violation was committed, and we hold all civil fines in abeyance and
Are you
encourage
gonna- are you-
property owners not to allow this to happen in the future.
I would like to suggest a little different, can I make a motion?
Sure, absolutely.
Regarding the civil fine, the ordinance prescribing the penalty for this offense states that upon conviction, a person or entity may be fined not less than $75 and not more than $200 per conviction. So I move that we fine $75 and that we hold this fine in abeyance, subject to the respondent complying with the following terms and conditions, that there are no more further burning incidents on the property.
Second.
Okay, we have a motion, well, thank you. We have a motion on the floor by Steve that the fine would be $75 and that the fine would be held in abeyance. Is that correct? Did you say that?
Yes.
Okay. Based on the requirement that there would be no further burning at this piece of property. And the motion was made by Steve, seconded by Larry. All in favor, say aye.
Aye.
Opposed, nay. Motion carried.
Which one of these, is this the first one?
Yes, sir, it is.
We just did ugly in the wrong piece.
So we're getting ready to go on to the second. Okay, you ready for the
Ready
next
to
one?
move on?
Yes, sir.
All right, second case is, let me get. Excuse me just a second. This opened up here. All right, the next case be citation number 489. It'd be case number 17-0028. That's not what I got up there.
Do 488.
There we go.
Okay.
The address is 3103 Heather Green Boulevard, Buckner, Kentucky, 40010. It's a development. It's under construction. The owner's Mason Construction and Development, LLC, 6001 Claymont Village Drive, Suite 7 in Crestwood, 40031. The violation is under the stormwater ordinance 05-830-326, section 14, number 7, stop work order. Specifically states no construction activities other than those required to address deficiencies / violations are allowed on a project site when a stop work order has been issued. I've got Mr. Victor Peak, Oldham County Job Site Inspector, that issued the initial stop work order. I'll have him step up and give you the background information on exactly what occurred.
You solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your knowledge.
I affirm to the best of my knowledge. I'm Victor Peak, Oldham County Engineer's Office. I was called on or about April the 11th or 12th about mud in the road. So I made a site visit to the property and determined that the perimeter controls were not up and operational at a single-family residential home construction project. It was a pretty egregious type of failure, so I, instead of going to a notice of deficiency or a notice of violation, I went to a notice of violation with a stop work order. I posted a stop work order. And on the requirements of the stop work order was to get the perimeter controls up and operational, to clean the road and curbs, to protect the inlets, catch basin inlets in the road, and to reconstruct the driveway construction entrance. That was on April the 12th. I hadn't heard anything for a while. On April the 21st, I just happened to be in the area, so I did drive through the project. April the 21st, I pulled up in and noticed that there were contractors in the building working. So I went in and talked to them. I told them that they were working on a stop work order. With that being said, I did not send them home. I did advise them that they're working on a stop work order, and I suggested that they not be working. And I called Dan Perkins, the builder developer, and told him that he had workers on the project. He, at that time, stated that he thought he had met the requirements of the stop work order. He had installed some perimeter controls and cleaned the road. With that being said, I had never received a call to release the stop work order. The inlet protections were still incomplete, and the rock entrance was minimal. So I told him all those things, and he stated that he'd get back with me. That was on the 21st of April. On the 26th of April, or thereabouts, it was either 25th or 26th, he called me stating that all his controls were up and operational, and he was meeting the requirements of the stop work order. So I did a site visit on the 26th, and I took my photos. The perimeter controls were up and operational. The catch basin inlets were protected. The road was cleaned from back of curb to back of curb, and the construction entrance was reconstructed to a minimum standard. At that point, I documented the release of the stop work order on the 26th of April. That's where we are today. With that being said, it was noted that he had contractors on board during the stop work order, continuing with the project, and at least to a minimum of drywall and probably the better part of the inside of the house, because it was all stud when I placed the stop work orders, and it was all drywall when I came back to release the stop work order.
Victor, is this a picture of the original stop work order?
Of one of the two. I actually posted two. That is, the one on the left is the original on the date, whichever my date was. But yes, that's the original. And I also had one on the garage entrance as you come into the garage, and then one on the stud as you go into the home itself.
So
Correct.
it's a little hard to see that those are two pictures. Can you describe both of those pictures?
Say again?
It's a little bit hard to tell that those are two separate pictures. Can you
Okay.
point out the dates and what you're seeing in those
Okay.
pictures?
The photo on the left was taken on the 12th of April, and that is my stop work order posted on a stud as you enter the residence of what will be the residence from the garage on the 12th. And if you was to read the stop work order and the citation that came with the stop work order, it gives you the minimum requirements to release the stop work order. Also states that there will be no construction on the project. On the 26th, which is the date that I did go out there and do a final assessment of it, the photo on the right shows that the drywall is hung over that stud. The stop work order is still in place. They just kept on moving. That's kind of where we're at today. Yes, sir.
Thank you, Vic.
You're very welcome.
Darrell, is there anyone here representing Mason Construction?
Yes, Mr. Dan Perkins is here.
Okay, would he like to come forward? Would you like to say anything? Do you have a moment? This is your time to speak. I need you to raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give this board is true and accurate to the best of your belief and knowledge?
Yes.
Could you state your name and address, please?
Daniel M. Perkins. It's 6244 Old LaGrange Road, Crestwood, Kentucky, 40014. All of this he said is true, except for on the 13th, I was notified on the 12th by two people, by Vic and also by a homeowner that I know that lives in the subdivision. I'm the original developer of the subdivision. And we mobilized the next morning, and by noon, we were out there working on the site. The cause for the mud in the road was not the silt barrier on the site itself. It was from a drywall truck that was delivering drywall that came in from a lot next door, drove all the way across that lot, up into my lot where the fresh dirt was, and got stuck right in the middle of the lot. And they evidently had a wrecker or something pull it out, and they pulled the truck back out on the street, and that's what caused all the silt on the street. The silt barrier itself didn't cause the silt on the street. The silt barrier was up all the way across the front of the house. It turned up the driveway like it's supposed to. The left side of the driveway was down. The rock, there was rock in the driveway that silt, that it's been raining for a couple of weeks before, had washed down over top of the rock. The rock was all the way up to the garage door, and it was silted over, and people were driving in. This was after the citation. I guess the guys were out there working after the citation, which is true. And they pulled back out on the street and got mud on the street. And I was told about it, sent somebody right back up there and cleaned it up. Every time we were informed of the problem, we immediately responded to the problem. And we do with all silt problems, and you're always having problems with silt fence on all these jobs. We ordered a load of rock, put the rock on the driveway, and on the 13th, after we cleaned up, I did call Vic, and I can't remember if it was 13th or the 14th, and told him that we were up there, we'd already cleaned the street, and we had a broom sweep even on the Bobcat, and swept the street off. And he had evidently gone up there and done another inspection and wanted me to, that's when he wanted me to put the rock on the driveway. He said, you need to put additional rock on the driveway. And then he came back out and took another look at it. When the next time he came out, he said he wanted an additional curb inlet covered with silt barrier. So I sent guys back up there again and did that, and then called him and told him that that we had that in place. We also installed additional silt barrier from the property line of my lot all the way across the lot where the truck had run up. There'd been other cars that had pulled up in that lot, crossing that lot. So we ran all the way across the front of that lot. And the curb, the dirt is about this far down below the curb. So we put the silt barrier up, and we were gonna push fresh dirt on the inside of that. And it started raining on the 15th, and rained the 15th, 16th, and 17th. Again, it rained on the 19th through the 22nd. That's a total of 7 days during this. And I was out of town, received a phone call, and spoke to Vic on the phone, but I was on vacation. And I was out of town through the 21st through the 30th. And I wasn't there policing the drywall guys. They had stocked the drywall in the house, and I wasn't even in town from the 20th to the 30th, and it takes about 3 days to hang a house, 2 days maybe to hang a house. And they got in there and hung the house over top of the stop work order. So I know there were other guys up there working. My deck guy was up there. I told him not to go back up there and work. There was guys putting the aluminum on the outside of the house. I told them not to go up there and work, and then I left town. So I'm guilty as charged, but we've done everything we could to try to alleviate the situation.
Answer? Appreciate it. Thank you. Please have a seat. Vic, would you like to come up and offer any additional comments?
Yes, please. First, I'd like to state that he's not here for the violation of erosion control, or I would have brought all the pictures and all the documents. He's here for working under a stop work order that was not released. I could argue points back and forth, but I'm not prepared to do that because I'm not here for that type of violation. Thank you very much.
Thank you. Do you have any additional comment?
If Vic were notified.
You need to address up here. Thank you.
By telephone, that we were up there cleaning and finished the cleaning, and he'd gone out 2 additional times, then how can he say that he wasn't notified? If I'm supposed to be notified, if I should have notified him by email or writing, that maybe I should have, I don't know, but I was doing it all by phone. He was calling me by phone, I was calling him by phone. We were in constant contact this whole time, even when I was on vacation.
Appreciate it.
Hey, guys here working, trying to, like I say, alleviate the issue, so.
All right, thank you. At this time, we're going to open the board up for
I have
questions.
a question.
Who do you have questions of? Any of these two folks, or any?
Do you have any questions of any of the presenters?
Maybe, but that's not my question right now.
Okay. Go ahead.
Okay.
I'm sorry.
Well, I thought we were going back on some. I understand what you're saying, and maybe I'm just confused, but the citation is written under stormwater ordinance and not a stop work. I'm just confused on.
That particular ordinance, the stop work order was issued because of violation of that ordinance. And language within that ordinance specifically references that particular section 14, number 7, stop work order. That is word for word in the ordinance.
Thank you.
The citation was issued specifically for violation of the ordinance, quote unquote?
Yes, sir.
Without any specific section necessarily?
Yes, sir. It was section 14, number 7.
Was the section cited as under the citation?
Put on the overhead.
Yes, sir.
Man, I assume that's what I have in front of me here, this little. Okay, I see down here, stormwater, section 14 is the basis for the issuance of the citation.
Yes.
So chronologically, what happened was.
I mean, stop work order.
Right. The stop work order was placed on the property under the stormwater ordinance in section that's cited here. When it was discovered that they had violated the stop work order, a citation was issued, number 488, saying that they were in violation of the stormwater ordinance, which allowed a stop work order to be placed on the property.
Okay, all right. I'm all right with that. I don't know if that's what you were questioning or not, but
Thank you.
I think it's all right.
I have a question or two for Mr. Peak. During your normal course of site inspections, you discovered the violation of the stormwater ordinance. And at that time, you contacted Mr. Perkins, made him aware of that violation.
Correct, and I wrote it in a notice of violation, stop work order.
And you posted the stop work order at the same time.
Posted the stop work order at that time, and then went back to the office and wrote it up as the official document is what I'll call it.
So there was no, and this may be standard procedure, there's no time between the point you notice a violation of the stormwater ordinance and the time you issue a stop work order?
That was all at once, correct, because of the conditions when I wrote up. And I just have a photo of the initial conditions of when I wrote up, looking something like that right there.
And this mud and stuff is coming from the driveway. The silt fence, it looks like it's partially down there, and
The silt fence is down here at the driveway area, but that's not where the most of the sediment deposition on the road came from. But it was breached at the far end of the lot. They didn't just go around the silt fence. They went through the silt fence and around the silt fence at the far end of the lot, and evidently got stuck. And upon exiting, left a mess that they didn't clean up, and I got the call the next morning. That's what I understand has happened.
oh, you responded to a call
Correct.
on a complaint?
That's
Okay,
correct.
Okay. And then when were you contacted by Mr. Perkins? The next day?
When was I contacted by Mr.?
When he called you in response to the stop work order and the citation the next day or two?
We spoke a couple of times over the next couple of days as he was cleaning and doing his repairs.
Okay.
Yes. And during those conversations, I noted that if you read the stop work order, it states that you have to have written release from the county engineer's office prior to construction. It's written right on this and the stop work order that was posted on the building, trying to make him aware that when you're ready, let me come out and release this through the proper documentation.
Yes. I don't have any more questions for Mr. Peak.
Anybody else?
Anybody else? I have a question or two for Mr. Perkins, if you'd come up. So you received a phone call from Mr. Peak at the same time he placed the stop work order and the violation of the ordinance. You were aware of it, and you started working on it, but you did not have written authorization to release the stop work order. Is that correct?
No. Yes, that's correct. But, and I'm trying to recall how it all went, but I received, this happened during the day, and it seemed like it was between, 12 and 5 when the truck got stuck. And we had a big rainstorm that day, and they tried to get up in there, just couldn't make it. So, I wasn't aware of the situation, and about the same time, I had a homeowner call me about the same time Vic called me. And it was right at the end of the day, and I can't remember exactly what I said, but I'm sure I said, we'll be out there. As soon as we get out there in the morning, we'll get out there. And by the time we got the dump truck and the trailer and the skid loader and the broom and got everything loaded up and some guys, it was noon before we got out there. And
The following day.
yeah, the 13th, yeah. And it was cleaned up that day, It took 3 hours to cleaned it all up. And there were other conversations that we had regarding additional work that he wanted done, which was the rock in the driveway, covering up the catch basin, I believe, and then he wanted the other catch basin further down the street was, I think, another call that went on, at another time. So we were in touch, 3 or 4 or 5 times.
Okay.
Yeah, the dirt in the street was the very next day. It was gone.
And you testified earlier that you did this cleanup work, and then left on vacation.
Yeah, but there were days.
So you
between
weren't
that.
aware that, of any further storms or rain incidents that caused any further,
I'm not aware that there were.
there weren't any further after that then?
I
Okay.
received calls that, I guess, I can't even remember what the calls were, but about the stop work orders on the house, and people were
Right.
still working on the house. So, like I say, I'm guilty for that.
I don't have any other further questions.
I have one question. Did you schedule the drywallers?
Yes. I scheduled the drywall to be delivered to the house, and I don't schedule the drywallers to do the work. It's a subcontractor that furnishes labor and material, so I don't know when his hangers come. They might come at noon one day and work all night. They're Spanish, and they work all the time, So
Okay.
I don't know when they're coming and going. I would have to be there on the job to stop them, I guess. But, I'm not saying that I didn't do it. I'm wrong, in that part of it, They didn't stop working.
I understand.
It's my responsibility to make them stop, so.
Thank you.
Can I say one more thing? Or? So, in the ordinance, it has violations may be enforced through any of the following measures. And usually there's a notice of the deficiency, which says here, and then notice of a violation if there is a violation. And then I guess civil penalties, which is what this is. you know, the process, and well, not in Jefferson County, but in Jefferson County, you're informed of a situation and given time to clean up the situation. In this case, there was a stop work order put on my job immediately. And, you know, it was bad. There was a lot of mud in the road. I didn't realize that the problem was there. If I would have been there, I'd have told them to take the drywall back and not bring it until it was dry or until we get up in the driveway. But I, you know, can't be on every job policing every truck that comes and goes, so. I just think I should have been given more time before there was a stop work order slapped on the job immediately, and we responded immediately, you know, so. That's my
Okay.
2 cents there.
Mr. Perkins, I do have a question. As you are the main contact for all of these properties,
And when I think during one of my conversations, I'm sure that I told Vic that I was going out of town on vacation, and if there was a problem, to call Patty in my office. And his comment was, have them call me, you know, but if there was a problem, I would just want to make sure that we were trying to take care of it. And
all right, sir, I appreciate it, thank you.
What was your question, Cindy?
I was asking who, if you ultimately had, who's in charge?
Well, Mr.
And it
Perkins
was
stated
Mr.
he's a
Perkins.
developer, yes.
He's the developer, so,
I have one more question for Mr. Peak. Would you speak to the comment Mr. Perkins just made regarding the issuance of the notification with a delay before the stop work order? He read something from the ordinance,
The ordinance of.
where they do it in Jefferson County is what I think he was
I
referring
don't
to.
know how they do it in Jefferson County. The Oldham County Construction Site Runoff Control Ordinance states that when I get a violation, I can write a notice of deficiency. And I usually do when controls are up and have been breached or ripped or something along them lines. I can go right to a notice of violation when they just haven't even put the controls up, or I can go right to a stop work order when now I'm having downstream detriment to the storm system below and the folks that live in the development having to drive through the mud and track it into their homes. So I did choose to take that straight to a notice of violation, to a stop work order with a notice of violation, for the purpose of getting it cleaned up immediately, because I don't personally, professionally, I did not want to see the home under construction and nothing being done in the road, because I gave him 7 days to correct a violation. This has to be corrected first before we move forward, so that I documented it properly so that that would happen.
Okay, thank you.
Yes, sir.
any other questions of the board? Okay. How do we want to proceed?
Any other discussion? We ready to move
The
forward?
discussion, we ready to move forward? Okay, we're moving forward.
Okay, I'll start off.
Okay.
You want, unless you want to, Larry?
Fumbled the last one, I'll let you do this.
Oh, no, you didn't. In procedural matters, the citation was properly issued on April the 12th. I'm sorry, the citation was issued on April the 28th, 2017. And also, Mr. Perkins received a phone call as the respondent, who was the owner of the property. And notice of this hearing was given to the respondent. And the respondent is present at this hearing today.
Okay, we have a motion on the floor for, that the citation was properly issued. Do I have a second?
Second.
Okay, the second, all in favor say aye.
Aye.
Motion carries.
Now, I've got a question here before I proceed with and this is going to be under other code violations, because we don't have a specific suggestion for anything that relates to this. The ordinance 05830-326 is a construction site runoff control ordinance, but the ordinance that we are here about today is violation of the stop work order. And I don't see that ordinance number.
It is at Same
It's-
construction site.
Same ordinance number, okay, so we
Yes, sir.
use the
Yes, sir.
same one?
It's under basically the enforcement section of that ordinance.
Okay, I got you. All right, so, I move to find that a violation of County Ordinance KOC 05-830-326 was observed by the officer, on April the 28th, and that there is substantial evidence in the record that the violation was committed or permitted to exist for I'm sorry, if I have these dates, the citation is dated April the 28th, but in the information here I'm given, it states that April the 12th, Mr. Vic Peak issued a stop work order.
Yes, sir.
But the citation is dated on the 28th.
Yes, sir. Mr. Peak issued the stop work order on the 12th.
On 13th April. I mean, I posted it on the 12th, but I actually did the documentation on the 13th.
It was posted at the building site on the 12th.
Okay, so these are two separate things here, that you wrote the citation
Yes, sir.
as
Yes,
the
sir.
code enforcement officer.
Yes, sir.
I got you.
When Mr. Peak went back to the property and observed the drywall, was hanging over a stop work order. He notified me, showed me the evidence. I went down there and I issued the citation on the 28th.
So you noticed, you issued the citation on 28th from Mr. Peak's visit from the 26th?
Yes.
Okay. That answers my question. So I'm going to revise my motion and continue here. Move to find that a violation of County Ordinance KOC 05-830-326 was observed by the officer on April the 26th, 27th, and 28th. And that concludes, really, that concludes that motion.
Okay, we have a motion on the floor. Do I have a second?
Second.
We have a motion on the floor and a second. All in favor, say aye.
Aye.
Opposed, nay. Motion carries.
And as for the remedial order, I'm going to move that I'm going to skip the remedial order and go straight to the civil fine. There were no previous convictions or violations. The citation and before I continue, I think I'm going to say the citation was uncontested, because Mr. Perkins admitted that he, in his testimony, that he did commit the violation. And that the civil fine for this be $75 a day for the 3 days that were noticed, and that all or part, all of the civil fine be held in abeyance, subject to the respondent complying with the following terms and conditions. That the well,
That's okay, just like that. That's okay, just like that.
that the civil fine Well, that, yeah, be held in compliance, that the civil fine be held in abeyance due to the property being in compliance, remaining in compliance
KOC,
with the violation, ordinance KOC 05830-326. I don't know if that, states what we're trying to do here.
well, what you're trying to do, you're holding it in abeyance based on some consideration that there be no further violations under the ordinance. And that's basically what you.
But that's honestly not the issue. The issue is there was a stop work order and work continued on the building, not the stormwater. You can't, the evidence, the reason it was
That's what we're talking about,
placed.
Jim, I think, is the stop work order was violated. Yet if there are other conditions of the ordinance that later appear, you're basically stating that you want no further violations under the ordinance. Because he's already, I mean, has there ever been a release of the stop work order? So there's been a release. Well, I assume, you know more about this, Jim, they could just hold in abeyance any further payment of fines. I don't know that you have to put any,
But again, how do you don't put any condition on that if that's where you're going, because
I'm
it's,
assuming you can just waive, imposition of the fine if you wish to do that.
if that's what you choose. I don't think you link it to future performance, because there may be an issue, and, again, this is only related, it's not related to the stormwater, it's related to the stop work order portion of that stormwater.
There's no condition to
If
impose it,
there's-
it's already been released, and
If there's a future violation, it starts another,
what?
another inspection or
Well, that's-
citation
I thought
or
that's-
stop work order or whatever it might be.
I think that's appropriate if there are further violations of that ordinance, no matter what they are, that then they could collect on the fine. They've imposed the fine, but they're waiving it they're waiving the collection of it at the present time. Assume there'd be no further violations that take place on the property. I don't know what you've said in the past on stop work order
Well,
violations.
we've had a number of instances, not with this contractor, but where we haven't really had stop work order violations in the past. We've got one that we're pursuing, different person altogether, different property, but because of construction activity increasing, we're starting to see more violations of the ordinances, and we're starting to enforce those ordinances.
Well, if it appears that we aren't interested in collecting anything at the present time, then don't impose a fine.
Yep.
That's an
Period.
option, period.
And put a period there.
And if it comes back on other issues, then you can recall in your own minds
Right.
that this has happened here before. I mean, I'm not trying to interject. I mean, they can do what they want, but they're having trouble saying what I think they want to do. And there's no requirement. I mean, gentleman been straightforward. Yes, I committed a violation here. It's been cleaned up and taken care of, essentially. And I think you have the authority, if you choose to do so, you recognize that, but not to impose any fine at this time, based on the record before the board.
Motion's still on the floor. Would you like to repeat it, or would you like to modify it?
Right.
No, I'll repeat it.
Okay?
Just to repeat my motion, there were no previous convictions for this violation or citations. The citation was uncontested. The the ordinance prescribing the penalty for this offense states that upon conviction, a person or entity may be fined not less than $75 a day and not more than $4,000 a day. I believe is what is correct in my code book here. So I'm going to choose that we impose a fine of $75 a day for the 3 days, but we held that fine in abeyance. Subject to the respondent complying with the regulations for 05830-326.
Okay, so we have a motion on the floor that there were no previous convictions of this violation, the citation was uncontested, the fine is $225 that will be held in abeyance based on the respondent responding to KOC 058326. Is that correct?
Yes.
Okay, we have a motion on the floor. Do I have a second?
Second.
All right, all in favor say aye.
Aye.
Opposed, nay. Motion carries. Okay, we're ready for citation 489.
Yes, it's the third case, citation number 489. It'd be case number 17-0016. The address is 6205 Osage Road, Crestwood, Kentucky 40031. The owner of record is R.L. and Fayette Nichols, residing at 11300 Prince George Court in Louisville, 40241. A hearing was requested. The violations violated in the ordinance was the nuisance ordinance, KOC 89-800-846, Section 1 and Section 2. Section 1 lists lumber, junk, trash, debris, abandoned, discarded, unused objects, equipment, automobiles, furniture, stoves, refrigerators, etc. Section 2, maintaining a nuisance causing a diminution. I can never
Diminution.
Ammunition.
Diminution.
in property values of other properties. On April 3rd, I received an initial complaint on this property. I conducted an inspection and found household items, miscellaneous debris, trash, scattered in the front of the home, and there was a pile in the front of the home. It was scattered around by the side of the house at the garage end of the house. April 4th, issued a courtesy letter with a compliance date of April 17th. And those were 2 photos I took at the location. And they're kind of hard to see through the trees, the photo on the right. On April 25th, I conducted a follow-up inspection and observed that no improvement had been made on the property. So April 26th, I issued a notice of violation that was mailed to the owner of record with a compliance date of May 9th. On May 10th, I conducted another inspection and observed that issues were still not abated. Therefore, citation number 489 was issued. It was sent via certified mail to the owner of record, and a copy of it was secured to the front door of the home. And here's photographs of that visit. Now, on May 26th, I received notification from Mr. Todd Lewis. Apparently, he's an attorney for the owner of the property. Said the owner was currently hospitalized and that arrangements were being made to bring the property into compliance. On June 5th, Mr. Lewis forwarded me photographs and a receipt for the work on the cleanup of the property. And on the 6th, I proceeded to go back out, re-inspect the property, and basically it looks like a totally different house. Mr. Lewis is here. I don't know if there's anything you'd like to say.
Thank you, board members. I'd be, obviously,
Do we have?
I can't be a witness, as
Okay.
council knows, but I can represent to you what
You'll
proof
just state
would be
your name.
put on if there was a contest, but I don't think we're contesting any. The only thing I'd like to make sure the board's aware of is the property descended through the probate process, and so I represent the heir who inherited it. The address apparently, which is from PVA, as I understand it,
Yes.
for the initial violations, is the old address of the now deceased owner. So we had it appears a snafu with gathering all the mail on time in those initial couple notices. The final one, which was the certified mail, was received by the mother of the homeowner. The homeowner himself is hospitalized. His mother received the certified mail, provided it to me, and I did provide all the information to Daryl the next day, I believe, and then the homeowner hired someone within a couple of days and then had the corrections. And I guess, are those the correction photos? That
Yes.
Yeah. Okay.
Yes.
Yeah, so that's where we stand. I'm gonna ask the board, and I didn't think Daryl opposed to dismiss this particular one. I think the real issue is we need to make sure our address is correct.
So at this time, the code enforcement office is requesting this case be dismissed. Like I said, the home looks like $1 million.
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Okay, this case is dismissed.
Thank you.
Thank you.
Thank you.
Thank you all.
Do we still need to do the minutes?
I don't think we have the minutes, do we?
Yeah, there's some minutes here. I guess you just have to approve.
We're gonna wait till next month?
The minutes for May will be reviewed in July. You don't have them with us, right?
Right.
All right,
Okay, so
the
we'll do
minutes
the minutes for,
For May will be reviewed the next
all right.
code enforcement meeting.
Thank you all.
Any no further business? We're now
You
closing.
got one more, hang on.
Oh, I'm sorry.
Oh, we do have another?
Well, it's not a case, it's a review of an old
Oh, okay.
case.
I'm sorry.
And I just came across this recently. An old case that you all heard, and we even received a final order, was case number 16-0073. A hearing date was August of 2016. The property was 1435 Finley Mill Road, and it was a nuisance complaint. And the order from the board was you imposed a fine of $480 with $100 due immediately. The remaining $380 to be held in abeyance pending compliance with the remedial order and no new violations.
When was this from?
This was on August 3rd of 2016. So the property had to be brought into compliance by September 2nd, 2016. The details kind of get sketchy after that. I've got a copy of a lien that was filed for $100. So obviously the $100 fine was never paid. And I'm currently working on a complaint on that property for this exact same issue. But there was never a lien filed for the additional $380 that was held in abeyance. And before I go any further on that, I wanted to basically get with the board and make sure that filing that lien for $380 would be appropriate.
Well, if it was never brought into compliance,
Appropriate.
then yes. Was there a time limit on that, by September the 16th or something? So,
September 2nd, 2016.
so they didn't meet the terms of the remedial order, so yes, that would be,
Yeah, for some reason, only the $100 fine was leaned. It should have been the total amount, not, they should have paid 100, which they didn't.
and then the
Rest in
380
abeyance.
abeyance, yeah.
None of it was paid, so the total should have been paid. So rather than us just doing this, I wanted Darrell to bring this case forward it's still an open case.
Yes,
And just ask for your consideration so it's in the record of what we're doing.
okay.
So do we need to, we have a motion on the floor? Okay, we have
No, I don't know, we need to move on it.
I think it's the discretion of the enforcement officer, once it's been approved by the board previously, to take that, initiate that action. I don't know that it has to come back here, but it's nice to
Yep,
have these
again,
kind
I
of
just wanted to have a record in case, because
Okay.
there's maybe another case
Thank you for the
coming
courtesy.
forward.
We agree
that-
as a board.
There you go.
Thank you all.
That was really, since we're having a meeting today, I just wanted it in the record.
Okay.
All right, at this time, I would
Thank you, Darrell.
ask for a motion to adjourn.
So moved.
Okay, we are adjourned.
Make sure and turn off.
Thank you very much.
These were tricky today. You're always throwing these curves at us.